Hello everyone, I hope you are doing very great and you are safe at your home. So, myself Monisha and I'm legal intern at LEXIS and Company. Today I'm here to talk to you about the topic relationship between international law and municipal law. So basically, international law is applied in the relation of the state and to other subject of the international law, and in another hand the national or state law, which is known as municipal law, is applied within a state to the individual and corporate entities, which are the bearer of the rights and duties thereunder. Apparently, it might be looking that there is hardly any relation between the two systems as they continue to different legal system, each of which is designated to operate in its own sphere and its own area. The problem of relationship between the rules of international law and municipal law is one of the most controversial question of the legal theory. Originally, the relationship between these two laws was a matter of theoretical importance, but at present, this concept has acquired a practical significance as well. Thus, the relationship between the international law and municipal law has led to emergence of different theories, and we will discuss about it too. First approach is dualistic theory. According to this theory, international law and municipal laws of the several states are two distinct, separate and self-contained legal systems. Being separate system, international law would not such as form a part of the internal law of a state to the extent that in particular instance rule of international law may apply within the state. They do so by virtue of their adoption by the internal law of the state. Such views state that there is no supremacy of any of the law on the other as they acquire the different places. Another theory is monistic theory. Monistic theory was pronounced in the 18th century. It was put forward by two German scholars, Moser and Martins. According to their study, there exists only one set of legal system, the domestic legal order, and they denied that international law is distinct and autonomous body of law. It was also denied that there is no need for international rules to be incorporated into municipal legislation since they are made by the state themselves. According to them, municipal laws and the international law are part of one universal legal system, serving the needs of the human community in the one way or the another. Now we will discuss the practice of states regarding the relationship. So, practice of the state suggests that states have chosen to follow that theory which they themselves consider more appropriate in accordance with their political, social, and economic system. However, far international customary as well as treaties are applied by them is different from state to state. So basically every state have their own treaties and international customary. So first we will discuss the Great Britain. In Great Britain, customary international laws and treaties are applied differently. The customary rules of the international law are either universally recognized or have at any rate received the assent of the United Kingdoms are per se part of the law of the land. However, they are enforced only if so far as they are not inconsistent with the act of parliament. Treaties are conditionally primary by constitutional provisions. Certain treaties are binding on the courts only if an enabling act of the parliament has been passed. Then another state is United States of America. In USA, as far as customary international law is concerned, the position in the USA is more explicit than the Great Britain. All the customary laws which are universally recognized or has at any rate received the assent of the US is binding upon American courts and will be applied to them. And regarding the treaties, the USA follow that the treaties made or which shall be made under the authority of the US shall be the supreme law of the land. And now, finally, the Indian practice. As far as the application of the customary international law is concerned, it appears that Indian courts follow the doctrine of incorporation as adopted in Great Britain. Thus, Indian court will apply customary rules of international law if they are not overridden by the clear rule of domestic law. And so far treaties, it is submitted that they shall not be binding upon Indian courts unless they have been implemented by the legislation. So I hope you have understood this topic, and for more such information and for more such topic, subscribe to our channel and do not forget to share, like and comment. Thank you.